It has been a while for my followers, and I just want to share a little perspective over an ongoing debate, especially in our legal and criminal justice jurisprudence, as to the admissibility of a confession made on national television, to how extent we court treat such confession in supporting the culpability or otherwise of a defendant or a suspect, as the case may be, before the court of law. I must state emphatically that there is a difference between extrajudicial confession made before the law enforcement agents and extrajudicial confession made before ordinary person, like before the national television or before the village committee, as the case may be. Then, number one, you must understand that what are the legal framework that regulates the issue of confession in Nigeria criminal justice system. So I must state that number one, it starts with the foundation in section 29 of the Evidence Act 2011, which is very, very clear that a confession must be freely, must be voluntary, and there are not going to be any element of torture, element of coercion, intimidation, and all that, which means that the defendant or the person appearing before the court must have freely decided to make such confession before the law enforcement agent. But this provision of the Evidence Act has been severely abused, especially by the law enforcement agents, wherein in the court of law, the defendant may make the defense that I did not make this statement, or even though I have made it, I made it under duress, I made it under torture, because he has been protected under section 29 that such confession must be voluntary and free from any form of oppression. This issue, this allegation has actually continued to impact negatively on our criminal justice administration, especially during criminal trial. When such allegation is made, the court is under compulsion to order a trial within trial. A trial within trial in this process is a separate trial, wherein the court will start a fresh trial to determine the voluntariness of that issue of confession, which means it's just like a normal trial wherein the prosecution, who has the duty and responsibility to prove the voluntariness of that statement, will call his witnesses. The witnesses will be cross-examined and re-examined. The defendant has to enter his defense, and the witness will be cross-examined and re-examined. They are going to do an address the court as to the extent of their evidence, and after the address, the court on its own will now deliver a ruling. So this, to a very large extent, causes delay in the criminal justice administration. And to correct this mischief, in 2015, when the Administration of Criminal Justice Act 2015 came into force, it made a very copious provision in section 15 and section 17 of that act was very clear that if a defendant decides to make a confession, that confession must be in writing. And not only being in writing, must also be video recorded or audio recorded, or ensure that the lawyer or the counsel representing the defendant must be present when such confession is being made. And this to create a safeguard to avoid the issue of the allegation of oppression, allegation of involuntariness and torture, wherein in many cases has been held culpable for torturing defendant in order to extract confession from them. But in the ACJ, in that section 15 of the ACJ, from 2015 ongoing, the law enforcement agencies have also refused to comply, because the word used there that the statement must be in writing or may be recorded in video and audio visual. And these have actually taken a very long period of time for the court to actually interpret whether that provision is mandatory or whether it's mandatory, or the law enforcement agents can just disregard such provision. So in vis-a-vis, this matter has, in several decisions from the Court of Appeal to the Supreme Court, but in 2023, the Supreme Court laid the case to rest, especially in the case of Akeze versus FRN, the case of Friday Charles versus the State of Lagos, and the recent one, the case of Nnajo 42 versus Federal Republic of Nigeria, where Supreme Court has made it mandatory that any statement obtained without the compliance of that video recording is going to be impotent, null and void, and of no effect, and the court should not rely on it. Then this is when the statement is being made before the law enforcement agent. But we have a situation where someone will go to a national television and make a confession that I have killed Mr. A, B, C, D, E, F. And the law enforcement agent doing the investigation will print out such confession made at national DNA. I would like to rely on it as a confession before the court. Because confessional statement during criminal justice administration, very large extent, is very, very critical, because the court can rely alone on that confession so far it is positive and cogent and compelling and voluntary to convict an individual. And where it has been the 18-9 in every criminal justice administration, that it is better to allow 99 murderers to go free than for one innocent person to suffer, the court will be very careful to ensure that such confession was actually voluntary and not under compulsion. So in this regard, the statement made at national television, the law enforcement agency will also want to rely on such statement. The question is, can that have the weight of a confessional statement? And my answer is yes. Because, in such a statement made at national DNA, it will not have the same capacity and the same level with the statement made before the law enforcement agents. And you cannot begin to make the allegation of duress, compulsion, retraction while the statement was actually made before the national DNA. There's one thing, look at what happened in the case of Nnamdi Kanu. Just concluded a federal high. I believe that the case is now in the Court of Appeal. I will not go into detail. But the statement of Nnamdi Kanu made before the DSS was actually rejected in evidence. The reason given by the judge is just two. Number one, there is a video recording of such statement, but his lawyer was not there when the video and handwritten statement was made. And based on that, the trial judge at the Federal High Court rejected it. I believe that Supreme Court is also going to use this as a basis to develop and expand our criminal jurisprudence. Then another area of this is, if such statement had been made before the national television, can the maker of such statement go ahead to make an allegation that statement was not voluntary? Can they also what we call retraction in a criminal trial, where in a device say, no, this statement, I did not make it, I didn't sign, I was the one who made the statement. So in that instance, are we also going to allege that a retraction can actually take place in a case of confession made before the national television? Then there is this case of Evans the kidnapper. I think the matter is also at the Court of Appeal now, wherein the High Court admitted the statement of Evans during those days where police used to do parading of suspects. He made it before the media. So the statement was made before, wherein he made admissions, and the judge in his ruling stated that he was not even remorseful when such video was being recorded. And in that, the court actually relied on that confession made to the whole public and also televised on national television as a confessional statement against Evans. I don't know the stage where the matter is now in the Court of Appeal to actually know the position of the three wise men and that appellate court as to cope with all that. But there is also a case here, I think it's a Filipinos case, in the case of Paradoa versus the state of Philippines. What happened? There is a case of murder wherein this young man killed a lady and disposed the corpse. Then when the investigation was ongoing, the trail was very close to this suspect. He ran to the mayor of the city and said that my spirit is very troubled and I want to confess. The mayor said, no, you cannot confess only before me. Let us get a video camera and the media for you to make the confession. This young man, before the media and under the video, actually made the confession. And that confession he made during his trial was actually admitted in evidence and was used against him, that actually made that confession. And in that case of Filipino, he also alleged that no, I was threatened to gang confess before the mayor. But the court held that there are no evidence of such compulsion. And in that regard, that statement was actually admitted against him and used in evidence in deciding that matter. So I'm just trying to enlighten us the rules and regulations that guides the confession, so that tomorrow if you want to confess, you have to be very, very careful, ensure that all these rules and regulations are being applied, especially our law enforcement agents. Sometimes we can have a very good confession, but the lack of the capacity of our law enforcement enforcement agents to apply those rules stipulated by law sometimes makes a person that is guilty to walk away the net of criminal justice system without being punished. And also, we know that there are some instances where law enforcement officer can threaten and coerce someone to confess, to make a confession. So in that regard, ensure that those constitutional safeguard is in place to ensure that whenever that confession is free and voluntary, can actually stand the test of time and be used in a criminal adjudication, to ensure that a guilty person will not just walk away due to our negligence and ineptitude in recording confession from the defender. Thank you very much, and we'll begin to continue this enlightenment. And I say once again, God bless you.